Chapter 4 today. And we're just going to cover the highlights of Chapter 4. In a lot of ways, this is similar to ethics because ethics and then the legal liability kind of is absolutely being discussed as a result of all the wrongdoing within the accounting firms over the past decade. So legal liability. I am going to focus on what the highlights are that I want you to be aware of. So we know that accountants do have a liability, just as every professional generally can have a liability due to wrongdoing. And so we're going to talk about the different types of wrongdoing in what fashion. Potential liability may exceed that of other professions because the number of parties that are suffering significant losses, millions of investors as well as creditors, and amounts can be excessive in some cases, exceeding the limits of professional liability insurance. Liability can really be an issue with CPA firms when we're dealing with the users being the public, potential investors, and then investors that do invest, and as a result of the CPA firm potentially issuing material misstatements, they can be held liable for that. So we're going to talk about how this has really become a significant issue, and all the more a reason when a CPA firm audits a client, they have a strong interest to make sure those financial statements are free from material misstatement. So the scope for CPAs can be very significant. There's different reasons CPAs get sued. Now, the most common is negligence. CPAs do not perform the work they should perform. And as a result of their poor audit performance, they issue an incorrect opinion and get sued as a result of it. Some of the estimates made in preparation of financial statements get proven wrong. So we know that there are estimates in any set of financial statements. We've realized that's just a reality of the business. Yes, a lot of our numbers are based on economic transactions, but there are also a lot like contingent losses, warranties, depreciation. You know, these items are really purely an estimate of what we anticipate, and so sometimes estimates are wrong. They may be unreasonable. Other cases with liability can be due to factors such as the ability of the CPA firm to pay. There's a specific term we're going to discuss where even though they find several people at fault, sometimes it's the person who has the money. They might end up having to pay the whole amount. So we're going to talk about that in this chapter too. How do we even know, or where does a CPA's liability result from? What type of statutes or laws are in place? Those of you who have been in business law, are you required to take business law here? Mm-hmm. Business law, have you taken it yet? Yeah. Okay. You may be familiar with various types of laws. Common law is what the United States is very well known for, which we also call case law. So the decisions made or handed down from previous court cases are priority or take precedence in determining cases similar to that type of case. So common law generally is utilized when we're dealing in civil legal matters. Very generally when we're dealing with what we call breach of contract, failure to follow through on a contract, negligence or fraud, usually those decisions are handed down or take precedence due to common law, due to another judge making a decision on the case and then as a result of those facts, the decisions on the case are handed down similarly from previous cases. Statutory law are laws that are created through a legislative body. So statutory law happens when a certain legislative body, government unit, passes laws and regulations that may impose liabilities on CPAs. Statutory law is what happens when we relate to what we'll talk about, the Securities Exchange Act of 1933 and 34. It was legislature that came down and specifically states these are the guidelines and these are the laws that we're going to uphold. So there are ways in which a CPA can be held liable, some in the form of what we call common law or case law, and then some in the manner of statutory liability or statutory laws. How do CPAs end up involving themselves in legal issues? Number one, primarily breach of contract. What does that mean, breach of contract? Well, in the terms of just simply an audit, the CPA enters into an engagement with a client. And through a series of maybe not completing it on time, not completing it appropriately per certain guidelines, they're sued for breaching their contract. So, utmost of importance to make sure that things are handled and documented in a fashion that someone cannot, it won't be upheld that there was a breach. Another manner in which CPAs can be held liable is in the form of negligence. Now, it's important to know there's two types of negligence here, ordinary and gross. Ordinary negligence is a violation of legal duty to exercise a degree of care that an ordinary, prudent person would exercise under the same type of circumstances. So that's just ordinary negligence. Gross negligence is lack of even slight care. So it's really more extreme. Indicative of a reckless disregard of one's professional responsibilities. So one can be sued for ordinary negligence, but more often is the case, we're going to be dealing with gross negligence here. But know those two types. Next, we deal with fraud, the big F word. This is the F word, not what you guys are thinking. Fraud. It's intent to deceive. Misrepresentation by a person of a material fact known by that person to be untrue or made with reckless indifference as to whether the facts are true, with the intent of deceiving the other party and with the result that the other party gets injured. So there's, of course, always needs to be an injury as a result of this. You can't sue just because someone did something wrong. There's got to be damages associated. But fraud is definitely just disregard for the truth. And intent is huge. You knew the truth and you didn't follow it. Then we have something called constructive fraud. Constructive fraud doesn't necessarily involve a misrepresentation with the intent to deceive. That's called constructive fraud. Now, when we deal with statutory law or legislative passed laws, the two primary laws we're focusing on relate to the Securities and Exchange Commission of 33 and 34. This only deals with companies that are being traded publicly. Know what I'm saying? And so we have two acts that hold accountants to very high standards. We also can have potential criminal liabilities. Now, remember in business law, civil are issued from two citizens, one person to another. Criminal doesn't come from a citizen, it comes from the state, okay? So criminal happens by the state pressing charges. Civil are between two citizens. I didn't even talk about RICO, so you can just shut that off your list. So there are certain elements that a CPA can perform and also make sure they document and really justify to make sure that even if they would be sued, they could be protected. CPAs have a duty. They've been granted a license or given the benefit or privilege of having a license to conduct business and for the public, and with that responsibility or with that privilege, they have a responsibility to the public. It's only fair. I always think of physicians. They have been given a broad privilege to really speak into our lives. And with that privilege comes a mass of responsibility too. It can't happen one without the other. So we have a duty to the public. And as a result of that, we really need to make sure that we act responsibly and professionally. As it says, CPAs accepted a duty of due professional care. Now, when they breach that duty, there can be troubles. They can breach that duty as a result of maybe doing some shortcuts. And as a result of breaching that duty, if there are losses that occur from an individual as a result of trusting in that CPA and the financial statements that are incorrect, and they suffer losses, then CPAs can become responsible. Now, it's important to know, though, generally speaking, in suits, the plaintiff or the innocent party who has been harmed is going to need to prove that based on reliance of that CPA's financial statements, that's how they created, they lost money. Okay? So it's not as though they can say, oh, I've gone bankrupt as a result of this bad investment. Well, was that choosing to invest in that, particular company a result of the CPA's financial statements? Make sense? Yes.
I was going to ask, so if, say a CPA, did something wrong, whether it was on purpose or not, would they be held liable and accountable, or would it be the firm that they work for?
Usually it's the firm, but it will have, it really depends how they set it up. Generally speaking, the firm holds the liability insurance or the errors on omission on all the CPAs. But it will affect them, and So, now I'm going to shut this door a minute. So now we're going to talk about how CPAs have a certain duty to the public, and then how they can breach that duty. So what is a duty? It's defined by GAS, Generally Accepted Auditing Standards. The duty is described in the engagement letter also. GAS, as we've talked about in a previous chapter, talks about various standards that CPAs need to, and the firm needs to conduct themselves with. And the engagement letter should clearly spell out the terms of the engagement and the responsibilities of each party. Breach of duty happens when an auditor doesn't do what they say they're going to do. Or it could be that they conducted the audit, but they really screwed it up. And usually they're going to screw it up because they didn't perform the audit in the manner that generally accepted auditing standards require them to perform the audit in. It doesn't imply the auditors were negligent whenever misstatements are due to errors or fraud are later found. So just because there was a breach of duty doesn't necessarily mean auditors were negligent when misstatements were found due to errors or fraud that later happened. Doesn't always. Now, as we move on about liability, there are losses. You only sue because you're trying to recover monetarily from losses. Now, an interesting little side note, you know, and I'm not speaking with an audit firm and investors, but just in general, lawsuits oftentimes arise from emotions. It's amazing when communication can be instilled and an I'm sorry or how can I fix this, but oftentimes lawsuits happen because the emotions get so high. You know what I'm saying? People can't go back, step back. But there have to be losses to the plaintiff, damages by a plaintiff in order to hold a CPA liable. Now, there are certain ways in which a CPA can protect themselves. They can protect themselves by saying, what happened, the negligence that occurred wasn't about the result of them losing their money. So there has to be a direct relationship between their loss and what they relied upon. So what they're trying to say here is the negligence that was being presented there really wasn't what caused the plaintiff's losses. Or another thing they can say is that, yeah, we were negligent, but the audit company was negligent also, or the company we were auditing was also held responsible. So contributory negligence means both parties have a piece of the wrongfulness. And then the comparative negligence, let's talk about that down the road. Liability, oftentimes a judge can determine the percent of liability that is on the part of the CPA. But then we're going to talk about joint and several, where even though a CPA firm might only have a certain percent of the liability, a plaintiff can come back to anyone to recover all the damages. So that can be a risky or a scary piece in the CPA practice. Third parties. Any third party has to prove that the losses they incurred resulted from what the CPA did. So, I mean, there can be other types of engagements that were handled, but for the most part, we're trying to talk about audits right now, okay? But the plaintiff has to prove that those losses were about something the CPA did. And usually what happens, third parties seek to establish that it sustained a loss caused by relying on misleading financial statements, which were included in an audit report that really weren't correct. Okay, there's got to be some portion of a material misstatement. Material, remember, that's what we're focusing on. Or third parties would have to prove that the CPA was grossly negligent. Or depending on certain jurisdictions, you can get by with ordinary negligence, but usually not. okay? That's what a prudent person in the similar situation would normally do. Gross negligence is just not even slight care, okay? Not even exercising slight care, reckless disregard, okay? Make sense so far? So basically, I want you to know, the quiz might ask you which case law relates to a specific type of situation. The Ultramaris case shows the auditors knew that the audited financial statements were for use for a particular purpose by a known user. So we'll talk about when third-party beneficiaries can sue because the CPA knew a third-party user was going to use these financial statements for a particular purpose. And then there is a situation where it's called the foreseen user approach. What that means is the auditor knew the audited financial statements were for use for a particular purpose, but the auditors did not necessarily know the specific user. So just because the auditor might not know the specific user, he can still be sued. And then this Rosenblum approach, which is from a case, is the auditor should have realized that it was reasonably foreseeable that the financial statements would be used by this user. So they're basically all third parties, but there are different extents of what type of third party is at play here. So let's go into detail. Ultramaris Corporation versus Touche or Touche. This is a significant case. You may have a question on your quiz. It was a case that is still in the books that shows, under common law, it established that auditors could be held liable to third-party beneficiaries for ordinary negligence, for third-party beneficiaries, and to other third parties for gross negligence. Under the Ultramaris, let me just take a quick second here. I'm looking on page 112. In this case, the defendant CPAs issued an unqualified opinion on the balance sheet of a company engaged in the importation and sale of rubber. On the basis of the CPA's opinion, Ultramaris, a factor, made several loans to the company. Shortly thereafter, the company was declared bankrupt, and Ultramaris sued the CPA for ordinary negligence. The New York Court of Appeals, the state's highest court, ruled that the CPAs should be held liable for ordinary negligence only to their client and any third-party beneficiary specifically identified as a user of the CPA's report. Then the court went on to indicate that the auditors should be held liable to unidentified third-party users for gross negligence or fraud. So what is a landmark decision here is that they were intended beneficiaries. The CPA firm knew that this company was going to issue loans based on their findings. So they knew about them, and the company went bankrupt, and they were allowed to sue for just ordinary negligence. This isn't reckless disregard. This is just didn't do what a normal person in the same line of work should have done. Do you see what I'm saying? Held to a very high standard. So just know that that case involves ordinary negligence with intended third-party users. That's the big deal there. Now, the Credit Alliance Court versus Arthur Anderson was a decision establishing that auditors must demonstrate knowledge of reliance on the financial statements by a third party for a particular purpose to be held liable for ordinary negligence to that party. So under this Credit Alliance, the New York Court of Appeals upheld, and they used ultramarres to use this credit alliance. The court stated that before auditors may be held liable for ordinary negligence to a third party, I might be saying the same thing, they must have been aware that the financial statements were to be used for a particular purpose by a known party or parties, and must have taken some action to indicate that knowledge. So the same thing is holding true there. The only way to be held for ordinary negligence, which is a strong stand, is because the auditors knew of those third parties ahead of time. Do you see what I'm trying to get at? And knew that they were going to rely on those financial statements for a particular purpose. Okay, now again, same purpose here. Rosenblum versus Adler established that the auditors could be held liable for ordinary negligence to all third parties that the CPAs could reasonably foresee as users of the financial statements for routine business purposes. So this gets even a little scarier. This happened basically in 1983. In this case, the defendant CPAs issued an unqualified report on the financial statements of Giant Stores Corporation, which showed the corporation to be profitable. In reliance upon these statements, Rosenblum sold a catalog showroom business to Giant in exchange for shares of Giant stock. Shortly afterward, Giant filed for bankruptcy and the stock became worthless. Rosenblum sued Giant CPAs alleging ordinary negligence. The case was dismissed by the trial court on the premise that the CPAs were not liable to unidentified third parties, because that's the way it has been in the ultramarres and the other one. However, the New Jersey Supreme Court reversed the lower court, finding that CPAs can be held liable for ordinary negligence to any third party the auditors could reasonably foresee as recipients of the statements for routine business purposes. While this approach has the potential to increase auditor liability, few states have truly followed this. New Jersey's followed it. This is scary stuff, okay? Anyone can get sued, or anyone can sue you. So basically, this case really opened the door for a lot of potential liability. So know, guys, this. Ultramarres is for a third-party beneficiary for ordinary negligence. Rosenblum is any third party the auditors could reasonably foresee as a user. Know the difference, because you could see it again. Now, as we talk about now the statutory pieces, you see those were case laws, common law. That's how it was ruled. These are now statutory laws. And in the 1933 Securities Act, what has to be proved by the plaintiff or the person with the loss? In the 33 Act, in all of the 33 and 34 Act, there has to be a loss. There have to be damages. And you see, there have to be misleading financial statements. Okay? You can't just have damages. You relied on those based on false information. Okay? Materially false information. But do you see in the 1933 Act, this says, there was a misleading financial statement, it has to be, but in the 1933 Act, guys, you don't even have to rely on them. So when people choose to audit, when CPA firms choose to audit companies that are getting ready to go public, you see the amount of liability in this scenario. A third party doesn't even have to prove reliance on the financial statements. They have to prove they had a loss, and they have to prove the statements were misleading, but they don't have to prove reliance. Now, what happens? What can a CPA firm do to get out of this? CPA firms follow auditing standards by the T. CPA firms document every single thing in their work papers because they're trying to prove due diligence. They acted in a manner that was beyond reproach. Okay? Even though they could have been misleading, if they can show they exercise such care, they can't be sued. But they have to show that. Under the Securities Act of 34, under one portion of it, the Section 10, they have to prove intent to deceive, manipulate, or defraud. The plaintiff has to prove that of the CPA firm. A little harder to do. But under the Section 18, the way an auditor can protect themselves is, again, showing that they did everything perfectly by the book. They conducted their audit according to GAS in its entirety. Due to their actions of good faith, they may get out of it. Does that make sense what I'm trying to say here? Now, when we're dealing with the Act of 33, remember, the auditor must prove due diligence. In this case, the auditors were unable to establish their due diligence, especially in relation to this one report that they had to issue for subsequent events up to the effective date of the registration statement. So they had some issues because the CPA firm could not prove it, and as a result, they were screwed. In Ernst & Ernst versus Hochfelder, the auditors could not be held liable under a rule for ordinary negligence. The U.S. Supreme Court concluded that the auditor's knowledge of the fraud must be proven before damages can be recovered under this provision, that middle case. The auditor had no intent to deceive, okay? And the plaintiff would have to prove that they did. Not going to worry about that, not going to worry about that. Criminal, again, when we're dealing with criminal liability, that's in the hands of the state. They were held criminally liable for gross negligence. 2 audit partners and a manager were convicted of filing false statements with a government agency, mail fraud, and violating the Act of 34. As a result of this, various disclosures are now required in financial statements. So there can be criminal liability. Well, we know, look at Enron, that was criminal. In this Act of 2002, the whole Enron collapse. The jury found, based primarily on an email message, that an Arthur Andersen attorney advised a partner to revise a memo to omit certain information, including a comment that an Enron press release that included an earnings announcement was misleading. Loss of this case put Arthur Andersen out of business. So it ultimately ended up being overturned, but Arthur Andersen is no longer. And at one time they were the largest CPA firm in the world. The SEC has a lot of power. Now, we talked about in previous chapters, the SEC has granted a lot of authority to the PCAOB. right? Public Company Accounting, PCAOB, something board. God, I hate that. Operating board or something. Anyway, CPA, if they're in enough trouble, can be prohibited from filing companies' financial statements. They can basically enforce all kinds of penalties on them. So SEC has a lot of power. PCAOB?
Public Company Accounting Oversight.
Oversight Board. Okay. They basically are the watchdog that can go in and do investigations, do some internal auditing of the companies, and could sanction them in various fashions. But everyone needs to be registered, remember, with the PCAOB if they in fact are conducting audits with public firms. Now, when we're dealing with non-public, so we're out of the public sector now, when we're dealing with non-public companies, there are a couple ways in which auditors provide services. One is called a compilation. Compilations are where they basically just prepare the financial statements based on the information that the client gives the CPA. I do compilations all the time. People come in for taxes, they provide me with their QuickBooks. They need compilations for their banks or various lending. I don't do any review on the financial statements. I compile a financial statement based totally on what they give me. Make sense? That's a compilation. There's no assurance I'm trying to provide. I'm just merely compiling the information. However, a review of financial statements consists on verification procedures that can be less in scope than an audit, but still more than a compilation. And it provides limited assurance as to the statement's reliability. Do you see how compilations aren't intended to provide any assurance? But reviews can provide limited assurance? In this case, this Tenants Corp versus Max Rothenberg, it's related to accountant's liability when they're associated with unaudited financial statements. This case demonstrated the importance of engagement letters to clearly establish an understanding with the client regarding the nature of the services to be provided. It also illustrated the need to follow up on unusual findings, even though they're not performing audits. Engagement letters make it real clear what each person is going to do and the responsibilities. Don't worry about that. So know this though. If the plaintiff is the client, the person who's going after the CPA is the client's going to have to prove under common law there was loss, there was auditor negligence, and they relied on those statements, and the reason for their loss was due to those financial statements. When we're dealing with third-party beneficiaries, no, there has to be a loss, there has to be negligence, along with also reliance and proximate cause. When we're dealing with these potentially foreseen parties, under certain situations there can be just pure ordinary negligence, but generally it's got to be gross negligence. And there, again, you always have to have loss. But, you know, the limited class of foreseen parties, third-party beneficiaries, CPAs can be sued for ordinary negligence. How do you prevent it? You know, why would anyone do this? Well, they can walk a certain walk that's going to protect them. Emphasize generally accepted auditing standards. Make it your Bible. When you get into issues or have questions, get legal counsel. Get enough insurance. And guys, probably the biggest thing is know your clients. Know your clients. I mean, really, one bad client can put you out of business. Know your clients before you get involved with them. Do enough work on the front to see what does the public think of them. You know, what's their history. Go in and learn about their culture. Just stay away from the bad eggs. Doesn't always help, but it sure does help a lot. And know the client's business. You really, you know, that CPA firm really needs to be, when I say an expert, very well bred in the sector of the business that that client is involved with. Always use engagement letters. Spell everything out. Even when you spell it out in writing, there's still confusion, isn't there? Carefully assess the risk of errors and irregularities, especially when we're relating also to weaknesses in internal controls. Exercise extreme care in audits of clients that have a high degree of business risk, which we're going to talk about in this next chapter. What is business risk? Carefully prepare and review working papers. So really, guys, in a way you leave this chapter and go, ah! Well, guys, anything worthwhile, wherever there's a reward, there's a risk. And so you minimize your risks. And that's what we're going to spend a lot of time talking about in auditing, is how to continually update risks. So, or be updating our potential risks so we can be aware of how we're going to change the audit. So that gives us the